This week's contract tip has to do with temporary occupancy agreements for sellers after closing. Those of you that have followed my contract tips know that I am not a fan of a seller staying in a house after the house no longer belongs to that person. I firmly believe, if at all possible, that the seller should have vacated the property prior to closing to avoid any potential issues. However, that being said, with the new CFPB TRID guidelines in place and potential disclosure delays and things like that, my opinion is there are going to be more sellers requesting temporary occupancy for a few days after closing, more than we've seen in quite a long time. That being the case, make sure that you as an agent use the proper documentation to put everything in writing between the buyer and the seller. Namely, that exhibit that you're going to use is the temporary occupancy agreement. Now, depending upon which contract you are binding under, which exhibit you use, the GAR Temporary Occupancy Agreement and the RE Forms Temporary Occupancy Agreement are vastly different. So I want to point out those differences to you. A couple of general guidelines or general considerations for you as an agent, regardless if you are representing the buyer or the seller, to keep in mind. Number one, the seller, if they are going to stay in the property after closing, please have the seller check with their hazard insurance company, because they will no longer have homeowners insurance on that property. So somehow that seller, that person staying in the property after they no longer own it, they might want to consider having some sort of insurance on their personal possessions. Number one, for them being in the house, and if something were to happen to them within the house while they are still there occupying the residence, or when they are moved, if they're moving, a lot of times if you are moving and still own a home, your homeowner's insurance will cover any potential damage a moving company might any damage to any property. So if you are on the seller side or on the buyer side, that's definitely an issue to consider between the parties, is making sure that the seller staying in the property after closing has some sort of insurance on their personal property items. The other issue is the time factor, the amount of time that a seller should stay in a property after closing. Now, check with the lender. The buyer needs to check with the lender, because for a loan that a buyer is getting, many loans have some stipulations on there that the borrower getting the loan must actually occupy the property within a certain number of days, so as not to have created a fraudulent loan. So that is definitely an issue to consider with the lender. The buyer needs to check with the lender on number of days after closing that they have before they do have to occupy the property. So now let me get to the specific exhibits. The GAR exhibit is F140, Temporary Occupancy Agreement for the Seller after closing. Now, remember, as an agent, you have access to the GAR contract forms if you are an authorized user of the GAR by virtue of being a realtor, member of a local board and the state board, or if you are an authorized user by virtue of paying the Georgia Association of Realtors to be an authorized user, or if you are a co-op agent and the other agent in the transaction is an authorized user of the GAR forms, then they can share those forms with you. For the RE forms, if you are an agent in our area, you have access to the RE forms. They are in your forms packages under Forms Pro in FMLS, as well as in Georgia MLS, and there is no charge for agents to use the RE forms. Just want to let you know, because when I go over what's in these forms, you may have a preference as to which form you use, regardless of which contract the buyer and seller are binding under. So again, the GAR form is F140, Temporary Occupancy Agreement for the Seller after closing. A couple of the issues I want to highlight within this form. Number one, it says during the temporary occupancy, seller agrees to maintain all the utilities in the seller's name and the bills and so forth and so on. It also states that the seller will not make any improvements or modifications during the temporary occupancy. There is an indemnity and hold harmless paragraph where the seller expressly releases the buyer, listing broker, selling broker, affiliated licensees from any liability of any nature arising from the seller's acts and anything that happens in that property after they no longer own that property, including injuries to persons, damage to personal property, so forth and so on. It is specifically understood that if the property is destroyed by fire or other occurrence during the temporary occupancy, the seller shall bear the risk of the loss to the seller's personal property. Again, the buyer will have the actual hazard insurance on the structure itself, but as far as the personal property items, that is what I mentioned before, as far as the seller contacting an insurance agent and finding out how to have those personal property items protected. It also states that the seller shall be liable at the seller's expense for repairing any damage to the property caused by the seller within this occupancy time frame. The occupancy, the condition of the property should be the same at the time the buyer actually does take possession as it was at time of closing, excluding normal wear and tear. Now here's the part that you may not be aware of. If the seller does not timely vacate the property by the end of the temporary occupancy agreement, the seller shall be deemed to be a tenant at sufferance, and shall be unlawfully holding over, shall be subject to being evicted, and shall pay the buyer a per day rent during the period in which the seller is holding over in the amount of blank, and you fill in that amount for each day after the temporary occupancy period that the seller remains in the property. So what that means, the seller staying in a property after closing is not paying the buyer a per diem for that time frame within which they are staying in that property. The only mention of money exchanging hands between the buyer and the seller is if the seller does not vacate the property at the time frame per the temporary occupancy agreement when the seller agrees to vacate. At that point, the seller becomes a tenant at sufferance and has to pay the buyer, who's the new owner of the property, a per diem amount for that holdover period. So again, there is no mention of any type of usage fee or anything like that. The only mention of money is if a seller does not vacate after the time frame is up. Regarding pets, the exhibit specifically states that the seller shall not have any pets in the property during the temporary occupancy agreement unless another agreement is signed between the buyer and the seller, namely a pet exhibit, which talks about pets and what happens at that point. And then this exhibit specifically states that this temporary occupancy agreement shall survive closing. Now let me go over specifically what the RE Form's temporary occupancy agreement states. And that is the RE Form 255 Occupancy Agreement for Seller After Closing Exhibit. Now, this one, like the other one, it also has a specific time frame that the buyer and seller agree where the seller stays in the property after closing when they no longer own the property. This one, the RE Forms exhibit, specifically states what I mentioned earlier, that many loans require the borrower to occupy the property within a certain number of days from the date of closing. So the buyer has total responsibility to check with the lender to make sure that this temporary occupancy agreement does not in any way invalidate or void their loan or their loan documents that they sign regarding when they are going to occupy the property that they have just purchased. Now in the RE Forms exhibit, again, RE 255 Occupancy Agreement for Seller After Closing. This one specifically does have a paragraph for compensation for the seller staying in the property, the right to stay in the property after closing. And it is called a usage fee. And the paragraph reads, seller shall pay buyer at closing a fee called the usage fee in the amount of a lump sum of blank dollars or blank per month and then it has a proration amount that you can fill in per day, beginning on such and such date and continuing thereafter for a blank number of days, the blank day of each month at the end of the occupancy period. All payments of the usage fee shall be payable to the buyer at the following address, and you fill in an address, and shall not be applied to the purchase price of the property. Failure to pay. If the seller fails to pay any fee due hereunder, buyer shall give seller written notice of default. Seller shall have 5 days to cure, so forth and so on. So again, the RE Forms exhibit does have a place to fill in a usage fee for the seller to pay the buyer for the right to stay in the property after closing. The RE form continues on that the seller is not a tenant. Neither of these documents, they both specifically state that these documents do not create a landlord-tenant relationship between the two parties, thereby invoking the landlord-tenant laws in Georgia. It specifically states seller is not a tenant, and there are no rights of the property as a tenant by virtue of signing this agreement. It is just a contractual agreement between the buyer and the seller for the right to occupy the property after closing. It also states, as the GAR form stated, that if the seller fails to vacate the property as provided herein, same thing, they will become a tenant at sufferance. Conditions of the property are the same. The condition of the property at the time the buyer takes possession, it shall be in the same condition as it was on the date of closing, normal wear and tear accepted. Maintenance of the property is the sole responsibility of the seller in terms of utilities, repairing any damages, so forth and so on. Also has the same admonitions for the seller regarding any insurance or potential loss of their personal property items, because again, they are not going to have hazard insurance insuring the actual structure in and of itself. So their personal property items, they need to get with an insurance agent and find out how to get insurance coverage for those should anything happen. RE Forms exhibit also has the same provision for pets, that no pets shall be allowed to occupy the property unless a separate agreement is agreed upon between the buyer and the seller, and it has a hold harmless paragraph, hold harmless and indemnification paragraph against all the parties for any potential damage or injury, and same provision as with many of the provisions that we have in our contracts, that the occupancy agreement shall survive closing. So I hope you have learned something. Definitely a discussion to have between whichever party you are representing, especially if a seller is going to stay in the property for an extended period of time after closing, regarding that usage fee or compensation. Very vastly different exhibits regarding the same issue. So take a look at those, read them in depth. Feel free to let me know if you have any specific questions I can answer. Thank you so much for watching. Again, Dana Sparks, broker with Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.